Okay, we're gonna try something. There's a little glitch here that's happening. Robert, I can hear you on the actual live broadcast. So we're just gonna have to do the best that we can through this. I can't, for whatever reason.
You gotta unplug the Yeti then, yeah.
I mean, because both of them.
Robert, so this is what we're gonna do. Talk now.
I'm here, right
Okay,
here.
I can hear you. So this is how we're gonna do this. We're gonna do it this way. I can hear you here on my phone watching the actual live. For whatever reason, I can't hear you through here. I'm gonna have to deal with that later. So I'm here, right here. I can hear you. So this is how we're gonna do this. We're gonna do it this way. I can hear you. There's a little bit of a delay here. For whatever reason, I can't hear you through here. I'm gonna have to deal with that later. I'm gonna go ahead and ask. Are you able to hear me, Robert? Are you able to hear me, Robert?
Yes, I can hear you. Yeah. Can you hear me?
Are you able to hear me, Robert? Are you able to hear me, Robert?
Yes, I can hear you. Yeah.
Okay, Robert, let's just go ahead. For those of you that are watching, I apologize. There's a glitch. I'm going to have to fix this later. But so because we all were here scheduled to talk about Riley, I'm going to let Robert talk. And Robert, just you're hearing me. So I'm going to mute myself. I'm going to ask you the question and then I'm going to mute myself and then I'm going to hear you here through here. So we're talking about Riley v. US. I don't know if it's the heading is US v. Riley, but in any event, we're talking about cell phone searches and officers, police officers. And listen, Robert, the public can hear you. Okay, they can hear you. So talk away. We're just gonna navigate through this situation.
All right. Well,
I'm gonna just ask you a question, and once your lips stop moving, I will ask you the next thing. Okay, and so this might be a little bit odd, but I'm going to mute myself when you're talking so that I can hear you here off of Facebook. Talk to me about Riley. I read the decision, 2014 decided. Interestingly, all 9 justices were unanimous in their decision. It's interesting. The other day, somebody asked me about what do you think of with Trump and the appointments, and people are freaking out now. How horrible and sad that Ruth Bader Ginsburg passed away. What an amazing life well lived. What an amazing woman. I saw today on Facebook you posting once you were admitted to the Supreme Court. How awesome. What an awesome photo. What an immense blessing that was that you were able to have a picture with her. Okay, such an amazing woman. So all 9 justices, they said unanimously, they agreed with the decision that you're about to talk about. Some people say, well, should we be concerned about whether it's Biden, it's Trump that wins? Justice Roberts was the author of the opinion, and he was appointed by, it was Bush, right? Am I wrong about that? Yep.
Yeah, 40,
and
43.
And Alito too. So they all unanimously agreed with the discussion that we're about to have, that we're going to inform hopefully the public. Everyone has cell phones. We all have a lot of private information in our cell phones. There are times that I have seen, even in the practice of law and with my colleagues fighting, Patrick LeDuc comes to mind. They wanted to force his client to reveal the passcode a couple of years ago, not too long ago. And ultimately they prevailed. But we see this often where officers stop persons, suspects. The Riley case, Riley began his encounter with the police due to a traffic stop. And all of a sudden they go in to look in his car, there's loaded guns, and then boom, they want to go through his cell phone. They did. There's another case that's addressed, another defendant. His name is Worry, I think. I hope I'm pronouncing that right. Same thing, but in that case, they obtained a warrant before going into his cell phone. So go ahead. I'm going to stay quiet. I want you to educate the public so that the citizenry, everyone here in our country, we understand the importance of the Constitution, the Fourth Amendment, in our privacy. And what a great opinion it was. So go ahead. I'm gonna leave you with that. I'm gonna mute myself and you talk and educate. Let's inform the public about this.
Thanks, Hedy. Well, let me first bring the audience through a little Fourth Amendment jurisprudence analysis. First, in order for the Fourth Amendment to apply, which is applies to unreasonable searches and seizures, no warrants shall issue, but upon a showing of probable cause. And of course, built within the Fourth Amendment are these judicial exceptions to the warrant requirement that have come about and we see in case law. So the first thing that our listeners need to understand in Fourth Amendment jurisprudence is whether the Fourth Amendment even applies. And the first question we ask is there government action? And to us defense attorneys or attorneys, generally speaking, that's the first question we have to ask when there's a constitutional challenge. So if the government is one of the parties, then the Fourth Amendment does apply. The next question we have to ask is there a reasonable expectation of privacy in this search that the government wants to conduct? And now that's a two-prong analysis. There's a subjective analysis and an objective analysis. So when asking if there's a reasonable expectation of privacy, the subjective analysis is, does this person have a reasonable expectation of privacy, number one? And the objective question for purposes of this analysis is, would a reasonable person have an expectation of privacy? And if we can satisfy that element of the Fourth Amendment, we have to ask the next question, which is, do the police have a warrant? And if not, if there's no warrant, is there a warrant exception? And all of us lawyers in law school have learned that sometimes the exceptions trump the rule. So tying this to the Riley case, one of the exceptions, as all the criminal defense lawyers know out there, is there a search incident to an arrest? And we know that that's an exception to a warrant. And then one of the other questions we have to evaluate, if there's no warrant, will the evidence get in anyway? And the three doctrines that we are familiar with are the inevitable discovery doctrine, which is the Nix v. Williams case, the attenuation doctrine, which is the Wong Sung case, and then the independent source doctrine. And then if the evidence is illegally obtained under the Fourth Amendment, then what is the remedy? And the remedy we've come to learn as fruit from the poisonous tree that we often call the exclusionary rule. So police should not be rewarded for illegally violating someone's Fourth Amendment rights. And as a result, the evidence gets suppressed, no matter how bad or damning that evidence is. So in terms of the case that we are discussing today, the Riley case, it's an interesting case, and we've seen some different results around the country in both state and federal courts with the application of Riley. What we're really talking about in Riley, and what Riley was and the cases following Riley, we're discussing what happens when say a cell phone is a cell phone protected. So Hedy was getting into the fact that this was a unanimous Supreme Court decision. It was, in fact, the search incident to arrest. So there was no warrant. And the U.S. Supreme Court said that the physical attributes of the phone are not protected. There's no privacy interest in the physical attributes of the phone. However, the data within the phone is, in fact, protected. Now, there's been several state and federal courts around the country that have allowed police to search phones. Now, this should be of great concern not only to defense lawyers, but to privacy advocates in general, because we store so much data on our cell phones, including emails, text messages, photographs, and certainly, without question, we have an expectation of privacy in the contents of our phones. So getting to Riley, the Riley court looked at, and the prodigy of cases thereafter looked at, what about if a cell phone is abandoned? Well, if a cell phone is abandoned, then the argument is that there's no expectation of privacy. And I think there's been some lower court decisions that have tried to analogize this type of fact pattern where the cell phone's been abandoned, and they analogize it to garbage that you throw out in your trash bin. That there's no expectation of privacy if you've thrown out your trash. The police, the FBI, the DEA, federal agents, they can go through your trash because you've abandoned it. And the same theory has been applied to the cell phones. So if we're dealing with abandoned cell phones, then Riley doesn't apply. I think that's clear. What about password protected cell phones? I've come to learn through some of this research that almost half of all people don't password protect their cell phone, which is surprising. And I think we have no definitive answer from different circuits. In fact, we have different circuits with different splits in authority on if, in fact, the contents are still there's still an expectation of privacy if it's not password protected. If it is password protected, we certainly see courts saying, yes, there is an expectation of privacy. So that's where the Riley court and the prodigy of cases that have come about after Riley have discussed in terms of the contents of a cell phone. Now, looking ahead, Americans exchange about 2.1 trillion text messages a year. There's certainly a lot of information to be gained from text messages. I know, as a defense attorney who handles international criminal defense and narco trafficking cases, money laundering cases, in many instances, cell phones that are obtained, the data on those cell phones is vitally important for multiple reasons, but certainly to connect defendants may be charged in a multi-count indictment with multiple defendants that may not even know each other or may know each other, but it allows the government to tie the defendants to people in that conspiracy. So that's where we are in terms of Fourth Amendment jurisprudence, Haiti. I don't know if you have any specific questions.
Okay, so thank you, Robert. Facebook's a little delayed, so I heard your whole everything that you discussed, and so what I want to discuss is this. These are the points that I want to make. These are helpful tips for the citizenry to better protect their privacy. One thing, and is, of course, and you can just nod yes or no in what I say. We should all password protect our cell phones. Yes. Okay. I want you to address this, and then I'm going to keep it kind of just like a couple of points so that then you can talk, and then you let me know when it's my turn. Give us examples of abandoning. How do we not abandon, or if we want to, just keep in mind that we're going to lose the protection and maybe make sure that there's nothing that that is private that we do not want discovered by the government. Talk a little bit about that. And again, just so what Riley establishes is that so that the non-lawyers, the lay people, so that they can get some information and to understand what their rights are. And I apologize to the public. I did say during the announcement earlier that we were going to take Collins, obviously because of the technical issue that I'm having that I have to figure out. That's probably not going to happen. You're more than welcome to put in comments for questions to Robert, but to just reiterate what you said, and after reading the decision, if someone is stopped, even a search incident to arrest is not going to allow the officer without a warrant, unless there's an exception, to search a phone, right? Could you explain that, kind of break it down simply for those who are watching, who are not lawyers, so that they understand? And so I'm going to mute myself now for you to respond to that.
Okay. Well, if law enforcement initiates a stop on a car or an individual, and the law enforcement officers do a pat down and maybe have they feel a cell phone, and then they pull the cell phone out without a warrant under Riley, they're not allowed to get inside that cell phone. Now the question becomes, if it's not password protected, can officers get in that cell phone? There's a split in authority amongst certain state and federal courts that some say yes, some say no. So there's really no bright line test. The key would be to have that cell phone password protected. It certainly has not been abandoned since it's on your person, and you are claiming, ownership interest in that cell phone. What becomes a little trickier is, what about information that's stored from your email on the cloud? Do you have a reasonable expectation of privacy in that third party host that's storing emails? And I think the answer, in my opinion, is yes. If I gave my cell phone to Haiti to use or to borrow, I haven't abandoned my cell phone. I simply am trusting her to use it and protect it like I would. Now, that might be a little bit of a leap of faith, but that's could be the same analogy made with cloud storage. So if law enforcement says, let me in your cell phone, the answer is get a warrant. And if there's no warrant, then they're not getting in your cell phone.
Robert, what about the cloud? So what if they're not able to get into your cell phone because they don't have a warrant? They're not able to get into the cloud either. Am I hearing you correctly?
I would agree with you. Yes.
Yes, is that correct? Okay. So can you explain that a little bit better? Let's say that with you're making a point saying that if it's abandoned, the cell, they can go in through the cell, but you're saying that they're not going to be able to go into the cloud?
I'm saying the government should not be allowed to search a third party.
Your turn.
I'm saying the government should not be allowed to search a third party host computer server that's storing your data, information, text messages, emails, photos, under some type of licensed user agreement, BAL-E, agreement. You still have an expectation of privacy in that data. I'm certain that there would be a a fight amongst certain state and federal courts as to the fact that the owner of that data has relinquished authority and control and maybe even possession of it to a third party, where a court could find that you've lost your expectation of privacy in that data if it's now given to a third party. But I disagree. I disagree with that scenario, that logic, if that would be utilized.
Well, because when we're entrusting our provider to store something, a third party, our private information in a cloud, we don't allow the third party to just share that information with anybody. They understand that they're to keep that information that we're entrusting them with private. So why should there be any type of understanding that we lose our expectation of privacy when we allow a third party to store our information?
That's a good point, and I agree with you. I don't think that we do give up our privacy expectations to that data. And remember now, even if we did give up some limited privacy, it was by consent to that third party. We're not consenting to the government to search the data contained within that third party host server. So there is a difference.
Okay, so Robert, I see that you're not talking, your lips are not moving, so there's a delay. I was trying to hear your response to my last point. It's 5:45. We've been on, I think, now for maybe at least 30 minutes, and it's been informative. It has, at least for me. I think we should table this if we want to like revisit, follow up on this. So what I want you to do is this. I want to wrap up. I apologize to the public for some of the technical difficulties this afternoon, but I still think that it was a fruitful, edifying conversation, and I think that for those of you that want to better understand what your rights are under the Constitution and to better protect your privacy, there's a lot to take away from here. What are some? Could you just, in a nutshell, give points to wrap up what the citizens should keep in mind as they go about living their life should they have an encounter with law enforcement? What are some good pointers as a recap of what they should keep in mind so that they don't see themselves having the government take their self and go through very private information? And I'm going to mute myself now.
So the Fourth Amendment is not dead. There are many exceptions to it, but it is not dead. One of the things I would like to remind our citizenry is that when U.S. citizens are traveling into the United States and before they come through immigration, once their feet hit that platform that leads you out of the plane onto the airport walkway, you are on U.S. soil. And if you are a U.S. citizen and are encountered by Customs, Border Protection, ICE, you have a constitutional right to be free from unreasonable searches and seizures. And law enforcement does not have a right to see or access the contents of your cell phone even before you get through immigration. I want to make that point clear because a lot of people don't know that they can refuse law enforcement's request to see the contents of their cell phone. Where have you been? What countries have you visited? That may be disclosed on your entry into the United States, but whatever contents are on your cell phone, They might want to hassle you. They may detain you for a little while. But guess what, folks? Unless they have a warrant, they do not get into your cell phone. And if they do, it's illegal. It's absolutely illegal unless they have a warrant. So a couple points to recap. Unless you have abandoned your phone, just like abandoned trash or the abandoned newspaper on a park bench, you have an expectation of privacy in that cell phone. You should password protect your cell phone. You should look at your user agreement with your cloud storage provider to make sure that you have no ambiguity about the expectation of privacy that you have in your text messages, in your emails, and that service provider will obviously honor that expectation of privacy. So as you go forth, keep your cell phone on you, password protect it, and don't be afraid to assert your rights.
Okay, I was here listening to you wrap up, but your lips are not moving, so it's my cue to speak. I'm gonna add this: always, when you are asked whether you consent to a search, I would always advise. I would exercise my right to respectfully tell law enforcement, no, I do not consent to a search. So. And I know I'm going to ask you anyways, but I know what the answer is going to be. You would agree with that?
I would agree.
You would agree, yes, with a nod? Okay. Okay, folks. Thanks for tuning in. I hope this has been informative for you. And Robert, as always, I love you very much. You're an amazing friend. I love you very much, brother, fighter, warrior. And thanks for sharing this time with me to reach out to the public, and so that they are better Americans, more knowledgeable about what their rights are, because rights are important, man, in this great country of ours, and the freedoms that we have and we enjoy, and we have to protect and fight for them. If you want to say anything, I'm not going to be able to hear you, but you'll have the last word, and then I'm going to wrap up and I'm going to end the broadcast. Everyone have a great evening.
If anybody needs to get in touch with me, they can reach out to me, 727-772-1941. And I'd be happy to answer any further questions, or if you need legal representation, don't hesitate to contact me. Thank you, Haiti.
Okay, yeah, I heard you say if anyone needs to get in touch with you, this is a serious, not nothing to mess around with when it comes to defending a case. He is number one for me. As far as if I was in trouble, this is who I would turn to. Robert Eckerd. Have a great evening. Haiti Oropesa, Florida, you judge. Till next time.